Good morning. Are you Brian Trejo?
Yes, ma'am.
And this is 26 DCCR 0132. Mr. Trejo is charged with aggravated assault with a deadly weapon. Mr. Rojas has filed a motion asking that I reduce bond, which is currently set at 300,000. And Mr. Rojas, you may proceed.
Mr. Trejo, Your Honor.
Mr. Trejo, raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can proceed.
Do you state your name for the court, please?
Sir.
What's your name?
Brian Trejo,
And Brian, how old are you?
18.
And where are you originally from?
Galveston.
You were born in Galveston?
Yes, sir.
Where do you live now?
Port Arthur.
You lived your whole life in Port Arthur?
Yes, sir.
Okay. Who do you live with?
My parents.
Your parents, and your parents started together and they're here today, right?
Yes, sir.
Okay.
Sorry, say that again.
They're here today, or his parents are
Okay.
here today. Who else lives in the house with you?
My brothers, my siblings.
And a lot of them are here today also.
So,
Brian, you know, your bond right now is $300,000. Your family's having a hard time coming up with the money for that bond, right?
yes, sir.
Okay. Well, I want to talk about you personally. Do you own any property in your name?
Yes, sir.
A home, a car, any land or anything like that?
Yes, sir.
Do you have a bank account in your name? Okay. My understanding, and tell me if I'm wrong, your parents own the house that they live in, right?
Yes, sir.
And it's already paid off.
Yes, sir.
Okay. And they're willing to help you out as far as trying to get you, get some money for the bond if we can go forward. Have you ever worked?
Yes, sir.
What kind of work have you done?
I work with my mom.
Doing what?
She cleans apartments, offices, houses.
Okay. Is that the only kind of work you've ever done?
No, the yards. I've done construction.
You did construction, with a company or working with a family member or what?
Yeah, family.
Okay. And all that kind of work, the construction work, cleaning offices, is that work that's still going to be available to you if you're able to make a bond?
Yes, sir.
Okay, and that's something you want to get back out and start
Yes,
working
sir.
to help pay for the bond if we're able to get it lower.
Yes, sir.
This is a serious charge, right?
Yes, sir.
Is this you're only 18? Is this the first time you've ever been arrested?
Yes, sir.
Even as a child, you have any juvenile cases? As a juvenile, were you arrested?
Yes, sir.
For what?
Unlawful carry.
Okay. And you're asking the court to lower the bond. We're asking for a $50,000 bond. I think that'll be enough, and along with if an ankle monitor or any kind of other conditions if the court wants to put on it. You're asking the court to do that, set that, and you think that's a reasonable bond, right?
Yes, sir.
Okay, I'll pass the witness, Judge.
Thank you, Mr. Rojas. Any questions?
What else were you arrested for as a juvenile?
Is it
Drug case?
possession of marijuana?
Yeah.
Speak up, please.
Possession of marijuana.
Thank you.
And what kind of weapon were you carrying when you were arrested as a juvenile?
Um,
Was it a handgun?
yes, sir.
And that's what you're charged with here is for shooting somebody. Correct?
Yes, sir.
Another question, John. Oh, sorry. What happened in the jail Saturday or Sunday?
Oh, I had got on the phone. Well, somebody passed me the phone, not knowing. Well, I didn't know somebody else was in line. Well, they forgot somebody else was in line. And when I was on the phone, somebody just came up and started punching on me.
The write-up was from the 8th, Your Honor, so you may not have had a chance to see it in full court.
Okay, thank you.
I'll pass those.
All right, anything else?
No further question.
Any other witnesses?
No, yeah.
Mr. Rojas, go ahead.
Yeah, Judge, I understand this is a serious allegation. He's a young offender, and obviously the handgun gives concern, both two different cases with handgun, and I understand the court's concerned with that. He's a lifelong resident of Port Arthur. He's not going to flee. He's doesn't have anywhere else to go. His family lives there. They own property. They own a home that they live in. They're not going to go anywhere. We think if you set the bond at $50,000, that's something the family will be able to make. And if it's at $50,000, they also, I would imagine the court's going to want an ankle monitor on this, and that's something that allows them a little bit of money to pay for the ankle monitor as well. You can set it at $50,000. And that's what we're asking the court to do.
Thank you, Mr. Rojas. Mr. Nichols?
I don't feel that $50,000 is sufficient to protect the community for someone who's been arrested for carrying a gun and is accused of having shot somebody at 3 o'clock in the morning. The allegation in this case is that he and some other individuals followed a young woman home from her place of business where she worked as a waitress and were harassing her, and then ended up shooting her boyfriend who confronted them. So I think $50,000 is quite low. and not sufficient enough, Your Honor. I'd ask that you set something much higher.
And I understand those are the allegations, Judge. Obviously, Mr. Trejo has a different story, and I have watched the video, and I don't think that some of the statements the police officers got are not in line with what's on the video, but that's just something that will come out later on. As far as who the actual shooter was.
Okay, but he's not denying that he was in the vehicle,
He was in the vehicle, he was, Your Honor.
the driver.
He was the driver.
Okay. The question is, I guess, and from all y'all's perspective is who was the shooter, but he was
Yes.
the driver.
He was the driver.
So I am taking judicial notice of the court's file, which includes a copy of the probable cause affidavit. The fact, Mr. Trejo, that you've already been arrested as a juvenile, which wasn't that long ago, because you're what, 18 or 17 right now?
18.
18. And I'm not sure what you were doing out at 3:30 a.m. In this situation, but it gives me great concern. Tired of guns, tired of people being shot, tired of it. Jefferson County's tired of it. I'm going to deny the motion. Your bond will remain at 300,000. If it's not already a condition of your bond, I am now making it a condition of your bond. If you make it, that you will be required to wear a GPS monitoring device and be on house arrest. If you're able to make that bond, and we'll reset the case for an announcement and get it taken care of as quickly as we can. You can go back with the bailiff.
Thank you.
Good morning. Are you Tristan Jones?
Yes, ma'am.
Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Hold on, I've got too many things. Right, Mr. Jones, in cause number 25, GCCR 1668, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from September 30th of 2025. The indictment alleges you were previously convicted of evading arrest or detention October 18th of 2024, and then after that was final September 25th of 2025. And then the indictment further alleges that you were previously convicted of possession of methamphetamine, state jail felony, February 8th of 2018. And after that was final, you were convicted of unauthorized use of a vehicle, a state jail felony, February 26th of 2025. And how do you plead to that charge? So to the original charge of evading arrest or detention from September 30th of last year, are you guilty or not guilty?
I'm not guilty.
Okay, so why did you do paperwork for a plea of guilty?
Oh, I didn't. I thought I didn't know you were adding all that together since 2018.
That's the stuff that we talked about, how you get to where you're a third degree felony. I explained it to you when we were in there.
I used all of that. A lot.
It is a lot.
I've explained the same at length, Judge.
So those prior offenses make it to where your punishment could be a third degree felony, which is between 2 years and up to 10 years. So the first two, the evadings, make it a state jail. So you've got a misdemeanor that is enhanced to a state jail because you've got more evadings. Then you've got more state jails from prior, which makes it then a third degree felony. Do you understand?
Yes, ma'am.
And that's what Mr. Parker went over with you?
Yes, ma'am.
Okay. So to the offense of evading arrest or detention with previous convictions, are you guilty or not guilty?
Yes, ma'am.
Guilty or not guilty?
Guilty.
To the prior offenses of evading arrest or detention, are those true or not true? Is it true or not true that you were previously convicted of evading arrest or detention in 2 prior cases?
True.
And then is it true or not true that you committed the state jail felony offense of possession of methamphetamine in February of 2018? And then after that was final, you were convicted of unauthorized use of a vehicle of state jail in February of 2025. Are those true?
This right here is the legal point of no return. Once he says true to those prior convictions, the enhancement is sealed. In Texas, admitting priors isn't just acknowledging history, it directly increases the punishment range. There's no jury deciding those enhancements now. He just confirmed them himself. Question for you. Would you risk trial with priors like that hanging over you? or take the deal and control the damage?
True.
Yes, ma'am.
True or not true?
True.
So did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So you can't change your mind later if I go along with this agreement. You understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation?
And here's the part people underestimate. Waiving the right to appeal? That's huge. If the judge follows the agreement, he can't come back later and say, I changed my mind. This is why plea hearings are so methodical. The court is building a record brick by brick so it can't be challenged later. Also, notice the immigration warning that's required under federal law. Even if it doesn't apply to him, the court has to say it. Every box checked. Every safeguard on the record.
Exclusion from admission to the country or denial of naturalization under federal law.
Yes, ma'am.
State tenders number 1.
No objections?
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that your a plea of guilty freely and voluntarily, and also your pleas of true. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest.
That's it. Once the judge says, I find you guilty, it's no longer a charge, it's a conviction. Notice how she confirms competency, voluntariness, and understanding before announcing guilt. That's not just formality, that's appellate armor. The record now reflects that he knew exactly what he was doing. The courtroom. Tone stays calm, but make no mistake, this is a life-altering moment.
Arrest or detention with prior convictions. Find those prior convictions true in the indictment. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows these were agreements, or this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. A firearm is a legal term. You should read that admonishment to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes, ma'am.
The court is aware, but he did just probably county jail time on most of those misdemeanors out of Harris County. He has done one lesser TDC amount, but he's never done as much as before. That was
Okay.
for it all.
And your honor, just out for procedural measures, he has a case out of Orange County. I'm not sure if they have a hold on him, but he thinks there may have been a PR bond set. I'm not sure, but I was hoping that there's somehow we could check him. So he doesn't go to TDC and then we can get him fit for the orange. I don't know if it's, no, we can do. Okay.
Yeah, I'm not.
I just thought I'd bring to
The
your
jail,
attention.
I mean, if there's a hold from another county, maybe the best thing to do would be call Orange County to
Okay.
let them know that we're done. And
I'll
they
do
might, if they can come get them somehow, but if,
I'll do that, Judge.
that would probably be the best route, because if they don't have a hold on them, then our jail's not gonna see it and
Okay.
and do anything with it.
Thank you,
You
Judge.
can go back with the bailiff. Thank you.
I already called it.